Ontem nós falamos sobre... Nós escolhemos alguns pontos da responsabilidade civil no Brasil que nós entendemos como mais complexos, ou mais palpitantes, ou mais relevantes, para mostrar para vocês um pouquinho do que acontece no Brasil quanto a provas, quanto à perda de uma chance, quanto a acordos e seguros de responsabilidade civil, para que isso funcionasse como uma introdução para o que nós vamos falar hoje e amanhã. Basicamente, também porque estes serão os principais pontos sobre os quais a professora Catherine falará hoje de manhã, hoje à noite, amanhã de manhã e amanhã à noite. Então, é esse link que eu acho necessário a gente fazer. Falamos sobre essas coisas ontem, para que agora a gente entre no direito norte-americano. Eu preciso dizer que é uma satisfação muito grande fazer esse encontro hoje e amanhã, de manhã e de noite, porque por pelo menos 3 anos a gente tem tentado trazer alguém dos Estados Unidos para falar um pouco sobre a prática das ações de indenização lá, aqui em Curitiba. E até agora não tinha sido possível. E dessa vez nós conseguimos. Então... Isso é uma coisa, é uma realização que me satisfaz pessoalmente sobremaneira. Como eu disse para vocês ontem, acredito sinceramente que a gente precisa mudar um pouco de referencial, de orientação, de exemplos e lançar um olhar sobre uma nova realidade. E, com toda certeza, o direito norte-americano, para mim, é essa nova realidade, que na responsabilidade civil é extremamente inspirador e inovador. A ideia do caráter punitivo da indenização por dano moral foi trazida de lá. A construção da perda de uma chance, apesar de no Brasil ter sido emprestada da doutrina italiana e francesa, majoritariamente, foi construída de uma forma bastante fundamentada nos Estados Unidos. E hoje está 1000 léguas à frente da nossa realidade. Por isso que, com toda certeza, eu acredito que é fundamental, pelo menos, tentar olhar para o direito norte-americano. E a minha esperança, o meu desejo mais sincero é que vocês tenham essa mesma impressão depois que nós terminarmos esses encontros amanhã à noite. E eu tenho certeza de que a melhor escolha que eu poderia fazer era a professora Catherine Shark. Nós temos conversado bastante, nós temos vários contatos em comum, e ela foi extremamente bem recomendada, não só por mim, como por esses nossos amigos dos Estados Unidos. E tem uma prática muito profícua na responsabilidade civil como um todo, especificamente quanto às questões que envolvem o que lá se chama de indenização ou dano punitivo. O que para nós é fantástico, porque esse é o principal ponto aqui, com relação ao qual a gente acaba indiretamente olhando para os Estados Unidos. Por isso eu peço que vocês prestem bastante atenção, porque vai ser extremamente enriquecedor contar com a participação dela aqui e ouvir a experiência que ela tem para nos trazer.
Thank you very much, Gabriel, and it's an honor to have been invited to speak here. I apologize for not being able to speak in Portuguese, but to make up for that, I'm going to try to speak more slowly than is my custom. It's a real delight to be here. I am a professor at New York University. I teach tort law, and I also teach regulatory law, lots of issues about health and safety from both the public side and the private side. I have had the honor to speak to various foreign audiences, but I've never been to Brazil. So this is my first trip, the inaugural one, and I have been very pleased with the hospitality so far. And again, thank you all for coming and for listening. Here's what I propose to do. I've divided my talk or presentation into 4 parts. The first part today is going to be, this morning, is going to be an overview of the tort law system in the United States. Yesterday, Gabriel, I think very appropriately, situated my remarks as suggesting that the United States might be a reference point. And I want to be clear from the start that I am perfectly capable and interested in criticisms of our system. A reference point need not be the goal to which one aspires. One can look at the reference point and be critical or use that as the starting point. But I did think it helpful to begin with some basics of our system. I don't do comparative law, but as I said, I have given numerous talks. I've been invited to be part of international tort groups. There's one called the World Tort Law Society, and my colleague from Harvard, John Goldberg, whom Gabriel referenced yesterday, myself, and someone named Mike Green are the founding North American members. So one thing that was interesting, I was thinking last night, reflecting on Gabriel's remarks about the United States as a reference point, and wanted to be clear that I won't be defensive about our system. I don't think our system certainly there are flaws in our system. I'm aware of those. I study many of them. But in this worldwide group, it was quite interesting. We were convening on products liability, and one of my colleagues there from Japan had started talking about the Japanese system. And at one point, he referenced the second restatement on tort, which is a project, as you might know, from the United States, from our American Law Institute. And as he was speaking, he called this the European model. And so later, again, not to be defensive, I said, it's interesting you are discussing the second restatement on tort, and you call it the European model when it's produced by the American Law Institute in the United States. And he said, yes, I realize that. I can convince my colleagues back home to adopt principles if we call it European and not American. So again, I'm not territorial about ascribing various principles to the United States, but I think that we can have some shared learning. I think notwithstanding very different systems, particularly the civil law, common law divide, various differences in our culture, in our socio-political background, there are nonetheless some principles of tort law that I think we can profitably discuss, and that's what my hope is for the set of lectures. So as I mentioned, this morning will be a broad overview. This evening, I'm going to be discussing causation and issues of proof and evidence, which will dovetail a little bit with some of Raphael's comments yesterday about issues of proof in the Brazil system. And then tomorrow in the morning, so maybe this is an inducement to get up early and come, I think it's a real highlight, at least one of my passions, as Gabriel was mentioning, is damages. I'm going to be discussing damages, which will be not only compensatory damages, but our notion of what are, unfortunately to my mind, termed punitive damages. I like to think of a broader conception of supra-compensatory damages. Damages that are given for purposes maybe beyond just replacing the actual loss through compensatory damages. So we'll discuss that tomorrow morning. And then tomorrow evening, I have two very important recent decisions from our U.S. Supreme Court I'll be doing as case studies. One is a punitive damages decision that also involves an insurance dispute, and so I think will illustrate some of the background principles I'm going to discuss today. And the second is another U.S. Supreme Court case that deals with the issue of federal preemption of tort law. So I'm telling you the scope of the lecture so you can understand why I've picked out certain features to discuss this morning about our system. Okay. This cartoon, I maybe should explain. It's one near and dear to my heart. I thought it might be appropriate here. It says, it's quite hard to read, I realize. It's from the New Yorker magazine. Do you have any picture books that could help a child understand tort reform. So what that's describing is that the issues of tort reform have entered our broader culture such that the broader public is discussing many issues in the United States. Obviously, it's quite absurd in one sense to think that a child would be needing to understand these issues, but how to reduce this into some form that would be explicable. My students at NYU like this cartoon because, as I've told them, I have a case book that we use when we're studying tort law, and I'm one of the co-editors or co-authors. Richard Epstein, who's now my colleague at NYU, was a very prominent professor at the University of Chicago and a very strong leader in tort law in the United States, and I co-author this case book on torts, and my students find it very interesting that I think that these present stories, very interesting, scintillating, engaging stories. In fact, I started telling, Gabriel mentioned that I have 2 young children, I started telling my son when maybe he was about 5 or 6, these tort stories at night, of course modified so that we didn't have horrific injuries. I wasn't trying to give him nightmares, but the basic point being that these stories really encapsulate very important issues about responsibility, about how we act as private citizens vis-a-vis each other. I let him be a judge and decide who should prevail in various of these stories. So they're dramas, and there is a human interest element of tort law, and I show that to the students to tell them, even though in our class we jump very quickly to talk about theory and doctrine, we don't want to lose sight of the fact that these are human interest plays, basically, that are affecting individuals' rights, their livelihood, etc. Okay, let's get started. So salient system features is the first part that I want to discuss. And actually, I was thinking about this as well, mostly inspired, Cesar, by some of your remarks yesterday about how in the United States, the way I would put it is that we have relatively thin or little what I'll call ex-ante regulation. The role of the state in terms of regulating things for our safety and health is relatively small. And that means that we have a very large area left for what we call ex-post litigation, right? And I think there's a kind of hydraulic effect. It's not perfect, but take, for example, I have 2 examples up here. The FDA, which is the Food Drug Administration, and the SEC, the Securities and Exchange Commission. These are both public regulatory bodies. So the FDA, for example, is involved in trying to ensure safety and efficacy of medical devices and drugs. The SEC is monitoring, right, the securities markets. And if we wanted to have a system where we just had public regulators, right? If somebody takes a drug, for example, and is injured by that, then they just deal with that through petitioning the public regulatory body and saying, you need to more stringently regulate the manufacturer. We could do that. But instead, what we have is we have a kind of mixed system where we have public regulators doing what I'll call ex ante, before the fact regulation. But we have a robust system, namely, I think the United States is fairly unique in terms of how much it relies on ex-post litigation. Take, for example, products. The United States is a country where it's relatively easy to bring a product to market. You don't have to go through a lot of government certification that your product is safe, et cetera, et cetera. However, once the product is on the market and harms someone, we have a robust system of tort litigation. And herein lies at least one of, I think, the paramount underlying theories of what tort law is trying to accomplish, which is deterrence or regulation of risks. So you could think of tort law, obviously tort law compensates individuals for their injuries, and that's important, but we've set up our system so that it's not just a broad, no-fault social insurance scheme, right? It requires certain elements of responsibility, and it pegs someone who's responsible for causing an injury with paying damages. And by that, the underlying deterrence theory, and this has been backed by numerous evolution of scholarships that has focused on law and economics in the United States, and looking at the idea that if, say, a product manufacturer is paying out future expected damages for the harm that it causes, it will internalize those future expected damages and will act at a greater level of safety, right? That's the deterrence goal of tort law. And so again, you could accomplish this deterrence through either having a public regulator set up standards of safety that must be met, or else have this system of tort litigation. So here what I say is what really sets the U.S. apart is the fact that its basic regulatory model, by and large, is ex post. We'll get into some shades and nuances, and it draws heavily on its common law tradition, right? Common law meaning that we have the evolution of principles of tort law case by case over time, and we do talk, and judges talk, fairly overtly about the underlying policy objectives of tort law and how to use law to effectuate those goals. In the United States, the scholarship or the tort scholarly community is, I should say, divided, though we're close friends, we communicate with one another, but divided into two intellectual camps regarding the underlying purpose of tort law. The first camp is associated with what we call moral corrective justice, and there are spin-offs of that. My colleague at Harvard, John Goldberg, is a proponent of this view. He calls it civil recourse, and the purpose there is that tort law is to correct or repair moral wrongs, right? If I do something and treat someone as a moral inferior and trample on their rights, then I have a duty or obligation to repair the wrong. You can see where the moral element comes into play. It's very much when we think about negligence law or fault-based law, thinking about someone who is a wrongdoer. Someone failed to exercise reasonable care. By doing so, they treated another as a moral inferior, and then the individual victim has the right to bring a lawsuit to repair that wrong. The second camp, and the one I should just put my cards on the table that I am associated more with, although I'm not an absolutist, is the law and economics inspired deterrence view. And that view came to the fore the very important figure in U.S. tort law, Guido Calabresi. Guido Calabresi was a law professor at Yale Law School. He was then the dean of Yale Law School, and now he is a federal court of appeals judge on the Second Circuit. So what's interesting is that in a book that he wrote in 1970 called The Cost of Accidents, he put forward what was kind of a novel theory about how we should look at tort law through the lens of economics, right? And the idea was what we're trying to achieve is an optimal level of safety, right? The optimal number of automobile accidents, let's say, in society is not zero. If the optimal number of accidents were zero, then we wouldn't have speeding limits that allow us to drive at speeds that are exposing others to risk, right? We could lower speed limits and definitively save lives, etc. So what's interesting to think about in this area is how do you achieve the optimal level of safety? It has to do with thinking about the costs of accidents in a broader way. The costs of accidents are not just what are the costs to the victim who is hurt by a tort lawsuit. You take those costs into account, but you also take into account the costs of preventing harms. So in other words, if it would cost, maybe it makes more sense to think about this in the product manufacturing sense. You are a product manufacturer and you make a product that has, let's say, 10 safety devices. And when you're deciding whether to add the 11th safety device, you look at what the cost of adding that safety device would be, and you compare it to the benefit side, namely the accidents that would be averted, the harms or injuries averted. So for example, if it would cost $1,000 to add the 11th safety device, and by doing so you would prevent $10,000 in future expected damages, then it's both efficient for the manufacturer to do that, and the very definition of reasonable care should be such that if you fail to take a cost-justified safety precaution, you have failed to exercise reasonable care, and you are negligent. So you can see that this view of tort law has to do, like economics, with allocation of resources. If you decide that you have a certain amount of money that you can deploy for safety, you want to try to deploy that in areas that will do the most benefit, the most societal benefit. What it is, and we'll see this as we go, is it's a way to look at an individual tort lawsuit, plaintiff versus defendant, as about more than just doing justice between the parties. Right? It's about trying to get our tort liability rules right so that we achieve maximum social benefit. Now it's interesting, our system, and it's one of the consequences of some of the salient features that I'm going to describe, our system, which is based heavily on insurance and the role of insurance in tort litigation, in effect has put into operation some of these principles, even though what you look at when you look at individual trials and judges resolving those trials is you look at the nature of individual litigation. In effect, some of the way in which our system has evolved, namely the vast majority of these cases are settled, the vast majority of cases are based on insurance proceeds, it looks much more like these are risk allocation decisions, and we are achieving certain goals of simultaneously compensating individuals, but also achieving societal goals of deterrence, etc. Okay. So, SEC, these are two, actually the SEC and the FDA represent two slightly different models of this balance between ex ante regulation and ex post litigation. The SEC really leaves a lot of enforcement action. It says enforcement, if needed, will occur only after allegations of wrongdoing surface. So the SEC does go out and monitor individuals who are trading in the securities market, but about 2/3 of the enforcement is actually done by private litigation once wrongdoing has surfaced. So that just shows you how, and I'm going to give you some figures later about class actions, etc., that one of the things to keep in mind before jumping to the conclusion that the United States just has a system out of control that people will litigate at the drop of the hat is that we are using ex post litigation to serve a very critical enforcement function. The FDA is in some respects an exception. It's not, these are nuanced distinctions I'm trying to make, but it's an exception in the following way. Unlike, as I mentioned before, other products, if I'm making a consumer product, it's very easy for the manufacturer to bring that product to market. I don't have to get governmental certification, etc. We're going to rely in the United States on ex post tort litigation to ensure that products are kept safe. The FDA is somewhat distinct. We have decided in the United States that prescription drugs and medical devices are different types of products. And the risks that they pose to society are so great that we have very stringent ex ante regulation of drugs, right? And the reason I bring this up right at the outset is later, I guess tomorrow evening, when I discuss one of these very important United States Supreme Court cases, it involves an individual who is harmed by taking a prescription drug. So we do have ex post litigation in this area, but it's one area that's fairly distinct because our ex ante regulation by the public regulator is very stringent. It's sometimes referred to as the gold standard. There's a class that I teach every summer in Basel, Switzerland, where we talk about the regulation of pharmaceuticals and medical devices. There are many pharmaceutical companies, as you may know, located in Basel. They are very interested in U.S. law on this, the FDA, et cetera, because in order to manufacture a drug that can be sold in the United States, which is a very big market, they have to meet those standards of safety. So we have decided, and I'm opening with this to just kind of plant the idea that there are choices that a society makes with respect to how to regulate health and safety issues. And in the United States, we have a balance between the state regulating ex ante and private ex post litigation. The first point is, as a broad brushstroke matter, we rely very heavily on ex post litigation. And Cesar, I was thinking about your comments because I think that has much to do with our tradition of skepticism about centralized state regulation and putting too much power and authority in the state. So we want individuals to be able to take matters, so to speak, into their own private hands to a large extent, whereas we don't do that necessarily across the board. I can, if I want to manufacture a pharmaceutical drug, just set up shop and start selling it, right? I would be put in jail. That would be illegal activity. You have to go through this rigorous pre-market approval process through the FDA, and once it gives its imprimatur of health and safetiness, then you can bring your product to market. We still do have ex post litigation there, and when we get to the case example where I want to explore this, one of the things to keep in mind is, might it be the case that where you have very stringent ex ante regulation and also a lot of ex post litigation, you've gone beyond the optimal point, right? But I think it's worthwhile keeping always in mind before we start deciding there's too much or too little litigation to step back and put it in the framework of who's regulating for health and safety. Okay, a salient feature of our system that thus far hadn't been mentioned, including, I know everyone's aware of this in the remarks yesterday, but I think we need to put front and center before we can understand the United States system as a reference point. And by that I don't mean that, and that is our use of juries. And by saying that, I don't mean to say I'm proselytizing and saying every other system should adopt juries. I think when we look at how our system operates and try to glean principles that might be more applicable in other systems, we should at least understand the role of the jury and how the role of the jury has played into the evolution of some of our principles. That's why I mention it here. The United States is basically the only country in the world where the civil jury continues to play a broad and central role. So the civil jury, that is a jury of laymen, is very important in tort issues, and we'll come to that. Basically, a very large percentage, in the upwards of in the 90 to 99%, depending on which types of torts we're talking about, these issues, if they go to trial, which is a small number of our cases, I'll get to showing you this figure, but not to keep you all in suspense. Basically, 97% of our tort cases settle or are dealt with outside of the trial process. 3% go to trial. So when we think about that difference, it's enormous. But of the cases that go to trial, they are, in tort cases, primarily in front of juries. In order to not be before a jury in a tort trial, both parties have to agree to waive the jury and to go before a judge. That happens, but it happens very rarely. Sometimes, and I'll show you some figures about that shortly. Civil juries, by the way, can differ in terms of the number on a state jury. And remember, I should have added this at the outset of the talk. When we're talking about United States tort law, it's a little bit of a fiction because we don't have federal tort law. Tort law is the prerogative of states. So we have 50 different states, and then we have Washington, D.C., and territories. But tort is state tort law. However, there are vast similarities among states so that we can have a course, for example, in the United States on U.S. tort law that talks about the common law of torts, that draws heavily from the restatement of torts that I talked to you about before, which are these massive projects that the American Law Institute takes on to look at dominant positions across the states and try to glean principles from them. But as you'll see in my lectures, we'll come to instances where I'll say some states do it this way and some states do it another way. We do have some form of experimentation going on with respect to different standards. And the number on a jury can vary from as small as 6 to up to 12, but the idea is these are lay persons. Everyone in the United States who's a citizen of the United States has to serve on juries. You're called for jury service. The idea is to get a cross-section of the population before whom the lawyers will present their cases. So it's a big feature of our system. In Europe, the jury is used quite sparingly, and generally speaking is only used in the criminal realm, not in civil cases. In England, which of course is where we borrowed all of our knowledge of the jury system, they have slowly moved away. There's no longer a broad right to jury trial in civil cases. They do have juries in certain cases, namely libel, slander, malicious prosecution, fraud, and false imprisonment. Canada, our close cousin to the north, comes closest to our model. But some Canadian provinces have eliminated the civil jury and others allow it a more limited role. So it's a fairly unique feature of our system. Here's an interesting chart, I think. This is showing you the percent of cases, and these colors might be a little difficult to discern. I'll tell you, the very high bars are the percentage heard by a jury. The very small bars are the percent heard by a judge. And this comes from one of our best sources of data on trial cases. This is the Civil Justice Survey of State Courts. The Department of Justice in the United States, the Federal Department of Justice, has a Bureau of Justice Statistics, and they run periodic surveys. This one's the most recent, unfortunately. They need to they've done a new survey. They haven't collated all the data. But what they do is it's a representative, it's a sampling of state courts throughout the United States in all of the various jurisdictions. It's the largest canvassing of data or information, and it's getting it directly from the court clerk offices, because some of our other sources of data that I'll talk about as my talk goes come just from self-reporting. They come, for example, from trial attorneys or defense attorneys who report awards and cases. As you can imagine, those data sets, although they tell us something interesting, are somewhat limited. Plaintiffs' attorneys like to report their large win cases, so there's a selection effect there. So this is drawn from a representative samplings of all of the jurisdictions across the United States. So along the bottom axis, just to read this aloud, we've got personal injury or damaged property cases, and if you can see, 90% of those are before a jury. When it comes to medical malpractice, the number is upwards of 98 to 99%, so you're talking about very few. It would be a very rare outlier medical malpractice case that would be before a judge. Then we have harms due to asbestos, again about 95% before a jury. Products liability that are non-asbestos, slightly lower, but upwards of 93, 94%. Premises liability, and then motor vehicle accidents. So for motor vehicle or automobile accidents, which are about half of the trials in this database, of those, more than 93% are before a jury. So that's an important feature of our system. Another important feature, and possibly more similar, I have some questions about how this works in Brazil, is the contingency fee system. Plaintiffs' lawyers, and the contingency fee is basically how tort litigation arises in the United States. So the plaintiff's lawyer in a tort suit is retained on what we call contingent fee, and that means that the lawyer is basically taking on the risk of bringing the victim's suit forward. And the typical contingency fee in the United States is 1/3. So the lawyer will get 1/3, right? The plaintiff's attorney receives compensation out of the funds that the plaintiff recovers. So if the plaintiff recovers a large amount of damages, the plaintiff's attorney will receive 1/3 of that, typically. If the action is lost, so the plaintiff attorney loses the case, then the attorney receives nothing. So that's why we have the plaintiff's attorney as the risk bearer. Plaintiff's attorneys in the United States typically self-identify as entrepreneurials, risk takers. It's interesting when I look at my students and the practices that they go into. It's kind of a difference somewhat in temperament, in business acumen, etc., whether they want to go into plaintiff's attorney work or defense work. Not the only thing. Many of them are passionate about helping victims in society, etc. But I'm saying that's an interesting feature because defendants are commonly hired, whether hired by a firm or directly by the insurance company, and we'll come to that, they're hired on an hourly wage. So the compensation on the defendant's side is much more stable, predictable, etc. At the moment in the United States, what's interesting is that it's wrong to think about it as the haves against the have-nots. Sometimes people have in their mind the idea of large firms that do defense work up against the solo practitioner plaintiff's attorney. Now, we do have that model, but we also have some very well-capitalized plaintiff's firms that do class action plaintiff work, and they have enormous amounts of capitalization. So we don't want to think, when we're studying some of these issues, that it's always the idea of the little guy up against the huge resources of the defense firm. We do have a lot of sophistication on both sides. So this is in short, what are some of the advantages? If you think about our contingency fee system, what it does is it allows individuals, those who are victims of torts, to bring claims that they otherwise couldn't bring unless they had money to pay a lawyer. What do you need to convince a plaintiff's lawyer to take your case? Well, you need to have a meritorious case, one that you think you will win, and also one that you think you will get significant damages. So the plaintiff's attorney is really screening these cases and is figuring out whether it's financially viable to take on a particular case based on those two factors. And we'll come back to this notion because in the United States, one of the issues of tort reform has been capping damages, and in particular, capping damages in medical malpractice cases. That has had an effect on plaintiffs' attorneys representing plaintiffs, about the types of plaintiffs that they want to represent, and about whether they stay in that line of business or not. So just to preview that a little bit, most of the caps that have been enacted cap not medical damages like hospital bills, but they cap what we call non-economic or pain and suffering damages. There's been some research that has showed this has skewed, right, the case selection by plaintiffs' attorneys. In what way? Well, they're not as interested in cases by, say, the elderly or women who aren't working, etc., because the economic damages in those cases, both the medical and importantly the loss of future wages, will not be high enough to justify taking the cases. Whereas they might have suffered lots of pain and suffering, lots of changes in all the abilities to do what they do, whether they're non-market activities in the home, etc., or for the elderly. So we'll come to that, but at this stage I just want to say that's all due to the fact that the plaintiff's lawyer, in deciding which of these cases to bring forward, is making this kind of selection based on the likelihood of winning at trial and having the size of the damage award. Are disadvantages? Yes, right? It's often criticized. The system gets criticized, particularly from foreign commentators, that it, on two grounds, really, I only put one of them up here. One is that it allegedly over-encourages needless litigation, right? The plaintiffs can easily bring, the victims can easily bring their case forward. and the lawyers are just taking on the risk, then this will lead to too many lawsuits coming forward. And sometimes people say this is at the root of why we maybe have too much litigation in the United States. The second is some foreign commentators look at the contingency fee system, and I understand that's not the case here, but with some kind of horror. This idea that you're allowing the buying and selling of the right to bring your tort action. In a sense, right, the plaintiff's attorney is getting, you've sold to the plaintiff's attorney your future expected recovery. It's interesting, in the United States, we have a current debate going on, not about the contingency fee, but how much that could maybe be expanded, right? We're considering whether or not we should have a market in tort claims. So in other words, when I'm injured, right, it's not just that I am seeking a lawyer who will get some percentage of my recovery, but I could buy and sell on the market ex ante my future right to bring someone should hurt me. Right now, there are prohibitions, right, that keep that from being a robust market. But it is interesting because that's sort of where the debate in the United States is today. Fee shifting. This is an important part. In addition to the fact that we have a contingency fee system, a big difference is the American rule on fees is that each side bears its own costs in litigation, whether it wins or loses. So the loser, unlike the quote-unquote English rule, which I believe is what is followed here in Brazil, but I stand to learn here, is that the party who loses in court pays the other party's attorney's fees. That's not the case in typical tort litigation in the United States. So again, sometimes people think that the contingency fee coupled with this American rule will bring forward too much litigation, right? The plaintiff has little to lose, it is said, because if they lose, right, the lawyer is out of recovery, but they don't have to pay, the plaintiff doesn't have to pay the defense side's litigation or attorney's fees. So in ordinary tort litigation, attorney's fees are rarely awarded. If it's an extreme case, you can ask a judge, and if the prevailing party can demonstrate that the other side made a very frivolous or a very malicious claim, then you can get attorney's fees awarded. But it's very rare. And obviously, these fee-shifting arrangements is going to affect parties' willingness to both settle claims, willingness to go forward with litigation. And both sides, this kind of system, face fairly strong pressure to settle cases, right? Because there isn't this idea that if you prevail, the other side is going to be paying the attorney's fees. Okay, class actions. This is another salient feature of our system because sometimes when we talk about tort law, people have in their mind individual plaintiff against individual defendant. Now, we certainly have that kind of tort litigation. We see it in lots of medical malpractice cases, automobile cases, but we also have a rife and robust class action practice in torts. In particular, we've got, I mentioned before, some of those well-capitalized plaintiffs' attorneys firms. They do mass torts. They get involved in some salient modern examples to give you. Massive plaintiffs' attorneys firms got involved with the BP oil spill, representing classes of individuals whose businesses were harmed as a result of the oil spill. We have class actions in lots of mass tort type cases. There's a whole jurisprudence about which types of cases can be certified as a class action. The basic idea is that the individual plaintiff is representing a class of individuals who are not otherwise directly represented. So class actions are going to have much more rigorous control by judges. This is the one area, again, I was thinking, Cesar, with your remarks about here, how individual settlements have to go to the judge for approval. In the United States, it's just in the class action context. Once a judge has certified a class action, if those cases settle on a class basis, they have to go to the judge for approval. To my mind, that makes sense because they have to ensure that there's fairness, et cetera, not just for the named plaintiff, but for all of the unrepresented individuals who are in the class. So we do have heavy judge involvement. Again, in this modern example of the BP oil spill, we very recently, just in the last couple of months, have had a massive settlement of the plaintiffs with BP, and we also recently had an additional punitive damages settlement with Halliburton, another co-defendant. So we can talk, if you're interested, about those cases. But the existence of class actions is important for understanding our system. What are the advantages of class action? The classic advantage that's usually put forward is what's known as the negative value class. So the idea is, if one individual has been harmed, let's say it's a consumer case, and one individual has been defrauded in a very small amount of money, it would not be in that individual's interests to come forward and sue the company who had defrauded them. Maybe more importantly, it would not be in the interest of a plaintiff's attorney to take such a case. Even though it's a meritorious case and they could win, they have a high probability of winning on the merits, the individual damages are so low that it wouldn't be worth the plaintiff's attorneys taking the case. That's known as a negative value case. So the class action gives a mechanism, right, for allowing the plaintiff's individual to instead sue on behalf of the class of individuals who were all harmed, right? So the aggregate amount of damages is going to be enough to incentivize the plaintiff's attorney to take that case forward. Disadvantages, yes. And again, this is an interesting area. I've given lectures particularly in European countries like Spain and Italy, and other meetings of the European Tort Law Institute, which is based in Vienna. There are many countries who are very interested in learning how our class action system works in the United States, but it's fascinating to me because they all are very well schooled in the practice, in the academic literature. So when I speak with them, they say, well, we want to take the benefits of the class action, the way that you can bring forward these negative value cases, the way that you can make sure that there are equal resources on the defendant's side and the plaintiff's side, but we want to do so without introducing the abuses, right? And there are abuses. So the idea here is that there have been examples cited where plaintiff's attorneys take what are considered non-meritorious cases. So it's not that you have an individual suit that has merit but low value, but it's a frivolous suit, and a company would ignore that, right? Because it's a frivolous suit plus it's very small damages, and no plaintiff's attorney would take it. The idea is, if the plaintiff's attorney can aggregate thousands of individuals, maybe millions of individuals who have allegedly suffered the same harm, look what happens, right? They now have a very large aggregate damage case, but the presumption that I started the hypothetical is it's a non-meritorious case, but suddenly the defense is going to feel like they have to do something to get rid. There's more pressure to settle such cases. You often hear this referred to as the nuisance value, that a company will settle such cases even though they don't think they have value, and if they came at it in individual litigation, they might take their chances at trial, but faced with a large class action, it's too risky for them to even fear that a jury might wrongly, in their view, give liability for these cases. Also, a very important issue, and one that we'll return to, is there's a potential for conflicts of interest to arise between the plaintiff's attorney and their client. And in some of these massive class action contexts, the relationship between the plaintiff's attorney and their clients is very attenuated. If you were actually to speak to some of the putative clients, they don't really even know who's representing them, right? So the problem there is that plaintiff's lawyers, for example, might want to settle a case that an individual client, if they fully understood their rights and interests, would want to take that case to trial. So it becomes more difficult when you have a plaintiff's lawyer who's representing named plaintiffs, but on behalf of all of these unnamed individuals in society. And it's why, mostly for money damages cases, we structure class actions as opt-out, right? You have to give notice to all of the unnamed individuals, and they have an opportunity to opt out of the class. If they don't opt out of the class, right, then if there is a decision made in the class action, it will bind them, even though they never appeared at trial, etc. So it leads to this difficulty. One example of this was in a big settlement known as the Vioxx settlement, where private attorneys negotiated a several billion-dollar settlement with Merck, the creator of Vioxx. What they did in their contracts with their clients was quite controversial in the United States, because they basically persuaded their clients to accept the deal. Lawyers always try to persuade their clients to accept deals, but part of their agreement with Merck was that the settlement would only go through if a high enough percentage of all the victims signed on to the settlement. And so what the individual attorneys did is that they told their clients that basically they weren't forced to accept the settlement, but if they didn't accept the settlement, they wouldn't represent them anymore. So that was criticized in the United States as being going beyond just persuasion to accept the settlement, but basically forcing parties into a private settlement. So again, this shows you, I know it's not where the system is here, particularly because deals and settlements are so rare, but in our system, we do think about how to mitigate the potential abuses on the other side if you go too far. Stakes are very high, as I mentioned, in class actions. To give you some figures, the average value in 2006-2007 of a settled tort class action, $76.6 million. So these are very high stakes cases. As I mentioned to you before, this is what I'm talking about when we look to see who are representing these classes. They are typically very well capitalized plaintiffs' attorneys firms. In 2007, tort lawyers made $103.3 million in fees from settlements. Again, this is a figure that people who are critical of the plaintiffs' tort lawyers say that they are profiting too much from this system, allegedly at the expense, right, of their clients or victims. It's a high-risk endeavor, but it's a high-profit endeavor as well. Now, there's a very good study done by Ted Eisenberg, who unfortunately just passed away recently. He was a professor at Cornell Law School, and Miller, this is Jeff Miller, my colleague at NYU, who does some very good empirical research of class actions. So they looked at actual data. They had heard these claims about how the plaintiffs' attorneys were profiting at the expense of their clients, and they looked at the best data available from the period 1993 to 2002. And the source is here. I give you, it's in an issue of a journal called the Journal of Empirical Legal Studies, and it's called Attorneys' Fees in Class Action Settlements, an empirical study. So they looked at all of the information they could get from settlements of class actions, and they found, much to many in the United States at least surprise, that only 22% on average of the recovery was going to the attorneys. Now, the comparative here, right, is in your typical tort litigation with a contingency fee, the lawyers are getting 1/3. So it is less than that, and it surprised many people, because at least in the press, the typical story was how these plaintiffs' attorneys were enriching themselves and the money was going to them and not to their ultimate clients. But here we have 78% of these in the settlement class actions were going to the plaintiff class. Now, one reason this might be so, as I mentioned before, is that settlements of class actions are policed by judges. So there is some control over that, as opposed to just regular settlements of private litigation. Oops. Right. So again, the mean attorney's fee was actually slightly less than 22%, and we could compare this against the typical 1/3 figure. So again, it was surprising to many. It's interesting, in the United States, this happens again and again. We have a very active media, as well as a very active tort reform lobby that is populated by interests like the Chamber of Commerce, people that groups, lobby interest groups that represent defendants, insurance companies, et cetera, and they're very powerful. We have similar interest groups representing plaintiffs. Many times there are claims made. There will be individual cases that get highlighted as the prototypical example of our system out of control or abuses in our system. And then when you carefully look at empirical data, which I'm a strong proponent of, sometimes those claims are either overstated or it's clear that an atypical or outlier case has been used to represent what's typically going on. This is going to come up again in my lectures, just to preview. I guess tomorrow morning I mentioned I'm going to be doing damages. I'm going to talk to you about punitive damages. My guess is that most of you have probably heard of the McDonald's hot coffee case. No matter where I am in the world, it's amazing to me. I've been in China, Japan. These are places I've been talking about tort law, U.S. tort law. China, Japan, Spain, Europe, Taiwan. The one case, people might not know really anything about punitive damages, what they are, why we should use them, but they know that case. So again, I think there's some learning that's happened on the basis of both, A, misunderstanding that case even on its own terms, but also putting that case in perspective. So that's what I'm attempting to do with some of these figures that I'm giving you from actual data in the United States. Okay, insurance. Again, this was interesting to me to hear a little bit yesterday about the system here. Insurance is a huge part, I would call it a salient feature of our tort law system. It's carried by individuals and firms, even in situations where it's not mandatory. And I'll talk to you about some places where insurance is mandatory, but it's very ubiquitous. Down here I have the typical motor vehicle accident, and insurance is definitely rife in that area, but others as well. This is an important point. There have been many academics, and I think it's a point that's well substantiated, that say insurance drives tort litigation at this stage in the United States. What do I mean by that? Well, first, the single most important predictor of whether a tort victim is compensated is whether or not the tortfeasor was insured. It's the first thing when an injured person goes to a plaintiff's attorney, when the attorney is trying to figure out whether to take the case or not, the attorney will find out if the tortfeasor has insurance. If it's a doctor, they're going to have insurance. We'll come to that, right? It's going to be mandatory, and it's mandatory in most states. And even in states where it's not mandatory, you can't have privileges to operate, to perform services in a hospital unless you have certain kinds of insurance. So the amount of the insurance policy is going to be very important to the plaintiff's attorney's decision whether to take the case or not. Even in a case, let's say a slip and fall case, where someone goes to a plaintiff's attorney, it happened in someone's home, the first thing the plaintiff's attorney will do is look at the homeowner's insurance policy and see if there's third-party liability coverage. Basically, it becomes an important factor as to whether a plaintiff's attorney will take the case. And then, as I'm going to show you some figures going forward, if you look at the amounts that are received in either settlement of cases, it's very highly correlated with the limit of the insurance proceeds. There are basically conflicts as a result that can arise between insurers, the insured, and attorneys. And I want to talk through a few of those. They're basically 4 paradigmatic situations. Situation 1 involves an insurer and an insured, and a tort that's clearly covered by the insurance and that falls within the limits of insurance coverage. So this is the kind of thing, an accident happens in my home. I have insurance. I have homeowner's insurance. There's third-party liability coverage. Let's say I have $1 million in my policy. So although I'm the insured, but my insurance company will basically take over the litigation that's brought against me. They have a duty to defend that's in the homeowner's policy, and there's not going to be really conflicts that arise between me, the insured, and my insurance company. I'm happy to let them take over because the limit is likely to cover the full scope of the damages, so they will make the decision as to whether to settle or to go forward with tort litigation. And basically, there's not really a need for me to have separate representation or to worry as the insured that my interests aren't being fully represented. So that's situation one. Situation two is an interesting one where the defendant is the insurer itself. This happens very often in automobile accident cases, right, where it's basically just the insurance company is the company who's being sued directly. So obviously in that situation, there's no conflict that would arise between me, let's say the driver of the car, who injured someone in my insurance company. Situation three is very interesting to me, and it sort of portends, again, something to think about down the road in a system that has a well-developed insurance, a rife insurance system where tort litigation is basically being driven by the availability of insurance. Situation three involves conflicts that arise between the insurer and the insured. So these can be in two different realms. One is it's an accident type where there's going to be a dispute whether it's covered by the insurance policy or not. A dispute where I, as the insured, would like to say that it is covered by the policy and the insurer should step in, and the insured disagrees. So what's going to happen in those kinds of situations? Oftentimes the insured is going to have to get separate legal representation and is going to have separate negotiation with the insurance company. The second, and the one that's going to come up in the case I want to talk to you about Friday night, so this is the inducement to stick with me till the end, is a kind of dispute that arises where the amount of damages is in excess of the insurance policy. So why does this bring up disputes? Well, in a couple of different ways. The case that I'm going to tell you about, which is called Campbell versus State Farm Mutual Automobile Insurance Company, and this is a case that went all the way up to the U.S. Supreme Court and is really about punitive damages. But what's interesting is the underlying dispute was an insurance dispute where the insurer, who was State Farm, refused to settle a tort case. So it was an automobile case, and Mr. Campbell, who was driving the automobile, was clearly negligent and at fault for this horrific injury that happened, this automobile accident. And he had an insurance policy of $50,000 with State Farm. The plaintiffs asked to settle that case, right? There was a negotiation, and they would have settled the case for $50,000. State Farm refused to settle. Now, here was an instance where clearly the individual insured, who was at fault, had an interest in settling that case. Because if it's settled, right, at the limits of his insurance policy, he won't have to pay out in his own personal assets. The insurance company, for reasons that I think it learned to regret down the line, refused to settle, went to trial. The jury awarded $185,000, so $135,000 more than what was covered. And at that point, State Farm said, "Too bad, Mr. Campbell. I guess you should put your house up for sale to pay the difference." And it turned into actually litigation then that Mr. Campbell brought against his insurance company. And the claim was bad faith failure to settle. And it turned out to be a tort claim against the insurance company for which he received not only compensatory damages, but also punitive damages. So again, it's a little bit of a foreshadowing of an important case I want to talk to you about down the road. But it's important here because that kind of conflict arises many times where an insurance company might not want to settle at the limits of its policy. It feels like it's being extorted almost, right? They know what the limits of the policy are, so the plaintiffs are going to ask for that amount. and the insured is going to be all too happy to agree to such a settlement, right? So that's a kind of conflict that can happen and is something of concern in our system. Situation 4 is also interesting. It's where a defendant is self-insured. This was actually news to me. I knew it was possible, but it was news until I started getting very deeply involved in pharmaceutical litigation. Most pharmaceutical companies are self-insured with respect to failure to warn claims. It's a kind of high risk, high liability situation, and so they self-insure just by setting aside reserves to cover this kind of litigation. We do have that form of insurance going as well. Okay, let's see, I'm gonna a little bit some of these class action issues because I want to get to talking to you about I want to show you some more statistics. What I skipped over was just some statistics about insurance class actions, and we could talk about that in the question period if you'd like, but I want to give you some actual statistical profile of tort litigation and settlement in our system. This is again trial versus non-trial dispositions, right? I told you, so now it won't be a surprise to see this. Of all cases, we have 3% going to civil trials. We have 97% that are either settled or are settled through mediation or alternative dispute litigation or are disposed at. This also includes things that a judge disposes of at the outset of a case on the basis of motion to dismiss or summary judgment. So this is actually a great pie chart that I show my students when I teach tort law as well, because our casebook that they use is filled with those 3% cases, not only the 3% that have gone to trial, but then get appealed to the appellate level, because these are the cases in which the judges are elaborating our principles of tort law, so it's important for the students to be studying that. I think it's also important because although it will look by this graph that there's a very small shadow that the 3% piece of pie could cast on the rest, but settlement happens in the shadow of tort litigation. And again, Cesar, you were mentioning this yesterday, that it's not as if tort lawyers would just say, okay, let's make a deal, let's do it based on how much, I like this kind of case versus you. It's done based on the tort lawyer as a risk analysis analyzer, right? It's done with the lawyer's understanding what happens in those 3% of cases, what the likely outcome is, what are the chances that a judge would throw the case out on a motion to dismiss or summary judgment at the outset of the case. What if it goes to trial? What's the likely award that they would receive, right? So this small piece of pie, the 3% of cases that go to trial and then go all the way up through our appellate system are very, very important. I think our world would look very different, again, even though this slice of the pie is small. If it was non-existent, then the system would be very, very different. Okay, I think this is interesting to look at too. When you look at tort cases, and I think you would expect to see this at trial, of all of the cases that are brought to trial, plaintiffs win on average 50% of those cases, right? You would maybe expect to see that because if it were otherwise, right, if lawyers were not doing their job as gatekeepers and understanding the system, if it was clear that one side was going to win versus the other, then it would be less likely that these cases were going to trial to begin with. What's interesting is when you break down by types of cases. So here, this graph is called Civil Tort Cases, Plaintiff Wins. So these are cases in which plaintiffs actually win more than 50% of the time on average. Again, the data set that I'm using is this Civil Justice Survey of State Courts. Anyone who happens to be interested in data on our system can go to the Bureau of Justice website and you can look at the reports and all of this data. They also make this data available to scholars so you can get the raw data, which is fascinating. And if you're interested in a particular type of case, you can look at that data. So here, what are the types of cases where plaintiffs win on average more than 50% of the time. Animal attacks, right? Plaintiffs win about 75%. This is interesting because animal attacks are one of the small areas that are based on strict liability in the United States, not based on negligence. So negligence, right, is you have to have a breach of a duty of care. Strict liability is just if you act and cause damages, you're held responsible. And animal attacks are governed by strict liability, and there's a higher plaintiff recovery in those cases. Motor vehicle accident cases, of the ones that go to trial, plaintiffs win about 63% of the time. And then asbestos and intentional torts, slightly more than 50%. What's possibly more surprising is the next graph. It's called plaintiff loses. What this means is just that on average, plaintiffs are winning less than 50% of the time. This surprises many people, even in the United States. This surprises many judges in the United States who adjudicate these appeals. But I find this fascinating. Look at medical malpractice. And again, here, the smaller bars are percent of cases won by plaintiffs. The larger ones are percent won by defendants. So medical malpractice, which is usually singled out as this place where our litigation is out of control, the plaintiffs are bringing too much litigation against defendants, plaintiffs win on average 22 to 23% of those cases. It's interesting to think about why this might be so. There are various reasons that have been put forward, but there are only theories about this. One is that medical malpractice cases tend to be cases where sometimes the doctor has a very strong interest in going to trial, even if the insurance company would like to settle, because the doctor is worried about reputational interests and other things at stake if it's known and reported that they settled a malpractice case against them. So it may well be that more of these cases go to trial and would otherwise have been settled for that reason. There also are other types of requirements in medical malpractice cases. I'm going to talk about some of them this evening when we talk about causation and issues of proof. There are many states that mandate that there has to be expert testimony, that you have to have a more stringent standard for finding that a doctor breached a professional custom or standard of practice, etc. But I think it's just interesting to note that. The other categories are product liability cases and false arrest or imprisonment cases. Again, percentage win by plaintiffs are less than 20% there. Okay, we're going to talk in a separate session tomorrow morning on damages and about why they're awarded, some of the controversy involving them. For right now, I want to just show you some figures. It is true that median award amounts, and these are both in litigated cases, again from the Bureau of Justice Statistics, it is true that median awards have been increasing. For medical malpractice cases, the median award rose from 1992, about $230,000 up until about $625,000, and product liability median awards have risen somewhat more. So it is true that the median award amounts in the United States do seem to be increasing in both of these areas. For medical malpractice, the usual reasons given are increasing life expectancy and therefore increasing future projected life awards. But we're going to talk about those components in the separate session. Here we go. Sorry. So product liability jury trials, the median award amounts are 5 times higher in 2005. I got these figures slightly wrong. 749,000 versus 154,000. And for medical malpractice, they're nearly 2.5 times higher in 2005. So again, these are the median awards. That means that half of the awards are higher and half are lower. But they're not, even, these awards, it's hard for me to know whether to you they seem very high or not. To a United States audience, these median awards are lower than what most people think of, because most people have been, their experience has been seeing what very outlier, very high award cases look like in our system. Medical malpractice. We have some very good data in the United States on medical malpractice. It's limited because insurance data in the United States is often not publicly available. There are certain states, Florida and Texas, have publicly available insurance data. That means you can look at not only litigated cases, but settled cases. And that's really important, because if you got all your statistics or figures from the 3% of cases that are litigated, you're going to have a skewed perspective on the statistics. So in a study of Florida medical malpractice cases that used insurance data, 93% of claims that had multi-billion-dollar payments were settled without a jury. So the most serious cases seem to be settling. In other words, cases involving serious injury and death, you see a large percentage of those cases settled by the insurance companies, which surprises some people. Again, punitive damages, this is more controversial in a sense, because when you settle a case, you don't separately say a certain portion is for punitive as opposed to just compensatory. Usually settlements, the defendant, if they know they were responsible and they think they will be hit with not only compensatory damages, but punitive damages down the road, they have an interest in settling the case and calling it all compensatory damages. They have tax advantages for that. There are also insurability advantages. We actually have, this was interesting too, as I listened yesterday to the discussion by Angelica, is that on insurance. She was talking about how the historical evolution of insurance was that there was a kind of moral objection to third-party liability insurance in tort law, and that certainly is the case. We overcame that in the United States, and we have robust insurance markets. The modern debate right now in the United States is whether punitive damages should be insurable or not. And interestingly enough, we have a situation where there is variation across states. In New York, my home state, there's a public policy objection to insuring punitive damages. They're not insurable. They're treated as fines. There's a moral opposition to them. In the vast majority of states, actually, in the United States, punitive damages, some component of them, as long as they're not intentional acts, are insurable. So that's what's interesting, is we're playing out in a modern context some of the similar debates that we had historically about when does it make sense to insure against certain types of injuries or accidents. What this study found is that the worst cases, those that were involving very egregious or reckless behavior, seemed to be ones that were being settled, and they were settled for much higher amounts. So even though the parties weren't calling them punitive damages, the academic researchers who were looking at this data suggested that you could explain one component of these higher settlements as being a kind of private punitive damages component. I might mention just at this juncture that I have studied the BP settlement, which was a compensatory settlement with the plaintiffs' class. And I too uncovered in the settlement what looks to me like an embedded, quote-unquote, punitive damages component. Why is that? When you look at the settlement agreements between BP and the class of individuals who are affected, they have a multiplier. So the actual economic damages that were asserted by certain businesses, some of those, when they were losses of the fishermen, have a multiplier that's applied to their total losses. So it's a supra-compensatory multiplier, and it's part of that private settlement. I would argue that that component looks like it's an embedded punitive damages component. But again, we'll come to that. That's the kind of analysis that's going on in these medical malpractice cases. Various proposed reforms that are on the table in the United States. One has to do with having specialized medical courts. This evening I'm going to talk about issues of causation and proof. There's definitely been a move in medical malpractice cases towards requiring expert testimony, trying to give a lay jury some kind of guidance about what is going on in our system, but some have argued further that we should remove medical malpractice cases from the jury altogether and put them in specialized medical courts where the argument is there will be experts who can more clearly discern whether someone has been injured as a result of a negligent act by the attorney versus just an adverse event happened when they were in the hospital. Screening cases, again, this is the idea that medical experts, not just plaintiffs' attorneys, who decide which cases should come forward. Various forms of alternative dispute resolution. Abolishing the collateral source rule is sometimes put forward. The collateral source rule means that someone's damages are reduced by the amount that the victim has received from first-party insurance, like health insurance, etc. Limiting attorney's fees, and tightening up statutes of limitations. The statute of limitation is typically longer in tort cases, so whereas a contract dispute, let's say, would say parties, once they know they have been harmed, have to bring a case within 2 years. For a tort suit, states often give a longer period, from 4 to 6 years, sometimes even 8 years, and sometimes people argue that that's too long. And the final is thinking about establishing a no-fault system, right? Our system, the tort system, is definitely very heavily negligence-based. You have to establish breach of a duty of reasonable care. And various people have said that we should have an administrative law system, namely remove these cases the way we remove many automobile cases, the way we remove workers' compensation. In the United States, we have an administrative process. It's a no-fault system for injuries that arise during the course of the workplace, and those are by and large handled not by tort lawsuits, but through this administrative process. There have been various people who are critical of our system who suggest we should move to such a system, whether for medical malpractice or even some people have proposed we should do this with pharmaceutical injuries and the like. Okay, this brings us to the end. I can show you capping damages is another big reform. I'm going to be talking about that in the portion of the lecture that addresses damages. Brings us to the end, or the sequel to come, right, will be on causation and issues of proof, where I'll be highlighting some specific issues that arise in the United States in tort litigation generally, but also in these medical malpractice cases and how those actually get resolved substantively.